He stood alone in front of Congress, accused of contempt. What he said next made history. Before we dive in, let us know where you're watching from today. And if you like this story, don't forget to subscribe. The gavel struck hard against the mahogany, echoing through the congressional chamber like a warning shot. The room fell instantly silent. Cameras pivoted. Phones stopped buzzing. Every pair of eyes, journalist, staffer, senator, shifted toward the tall figure standing alone at the witness podium. Arnold Schwarzenegger didn't flinch. Dressed in a simple charcoal suit with no tie, he stood calm, his hands resting lightly on a leather briefcase. He didn't speak. He didn't blink, but the tension coiled around him like a live wire. From the elevated bench, the chairman leaned forward, his tone clipped, precise, and deliberately public. Mr. Schwarzenegger, you have been summoned before the Special Congressional Committee to respond to statements made during your recent United Nations address. Specifically, your comment implying that certain members of the judiciary have traded rogues for oil checks. That is a direct accusation, and it treads dangerously close to contempt. A low murmur rippled through the chamber. The clip had gone viral 2 days ago. Arnold standing before a packed room of world leaders, calling out what he labeled judicial sabotage against the climate. He never named names, but everyone knew which recent Supreme Court ruling he was referring to, a 5-4 decision gutting federal regulations on industrial emissions. Overnight, talk shows exploded. Some hailed him as a truth-teller. Others demanded his resignation from the Future Earth Initiative, the global environmental fund he founded after stepping back from politics. Now, here he was, summoned not for breaking the law, but for bruising egos. And yet, there was something uncanny about how still he stood. No bodyguard, no lawyer, no entourage. Just a man in a briefcase in the crosshairs of Washington's most televised inquisition. The chairman's voice sharpened. We understand your history as a former governor, as a global advocate, as a public figure. But this chamber is not a film set. This is not a monologue for your next documentary. You will either retract your words today or be referred for further investigation under contempt of Congress. Do you understand the severity of the situation? Arnold finally looked up, not with defiance, but with something colder, composure. I understand perfectly, he said. He didn't say more. Not yet, and that made them uneasy. On the back wall, cameras zoomed tighter on his face. The networks had already dubbed the event Arnold's Reckoning. Social media was split between hashtag Terminator on trial and hashtag Truthinator. Commentators from every network speculated what he would say. Would he walk back his words? Would he apologize? Would he break under pressure, as so many others had before this committee? But Arnold had spent a lifetime defying expectation. What the committee didn't know, what no one outside a handful of aides did, was that after Supreme Court's ruling, Arnold didn't run to press conferences or donors. He locked himself inside his personal study for 72 hours straight. No calls, no staff, just court transcripts, law reviews, and a half-read copy of the Federalist Papers. He wasn't preparing a defense. He was building a war chest of constitutional ammunition. Because Arnold Schwarzenegger didn't come to apologize, he came to respond. The chairman cleared his throat again, clearly expecting a statement. Then I ask again, Mr. Schwarzenegger, do you retract your UN comments? Arnold placed one hand on the briefcase, unlatched it with a soft click, and pulled out a thick folder marked with tab notes and legal citations. His other hand adjusted the microphone, slowly, deliberately. I do not retract my statement, he said, voice steady, low, unshaken. But I do have something to submit to the committee. 23 pages, all legal precedent, all public record, all relevant to the First Amendment, and to the question of whether calling out patterns of judicial bias in matters of public interest constitutes contempt or civic duty. Gasps were audible this time, not because of what he said, but how he said it. The chairman's eyes narrowed. Mr. Schwarzenegger, this is not a legal seminar. No, Arnold said calmly. It's something more dangerous than that. It's a place where truth makes people uncomfortable. That silence returned, heavier this time. No one moved. A single paper fell off a reporter's lap and fluttered to the floor. Arnold continued. I've spent decades working within the system. I've served in government. I've signed bills. I've vetoed others. I've sat across from oil executives and environmentalists. I've watched courts interpret law in ways that uplift communities and in ways that endanger futures. When I spoke at the UN, I didn't attack individuals. I challenged an idea, the idea that power should be insulated from criticism. A murmur of cameras clicking returned, but this time more deliberate, more focused. And if we reached a point in this country where a citizen, even a former official, cannot speak out against judicial decisions that impact our planet's future, then what we're holding here is not a hearing. It's a funeral for debate, for accountability, for democracy. He wasn't raising his voice, but every syllable hit harder than a gavel. The chairman opened his mouth, then closed it again. Arnold looked down at the folder, then back up. I will remain here as long as you need. I'm not above this process. I believe in it. But let's be clear about one thing. I came to defend a principle, not myself. With that, he pushed the folder forward on the desk. The camera lenses clicked in unison like a row of hammers cocking back. What happened next would not be about muscle or fame or politics. It would be about precedent and whether a man best known for his strength could summon something far more powerful, clarity. They thought they knew who he was. The action star, the former governor, the face on motivational posters, the muscle behind Hollywood's most iconic one-liners. What they didn't know, what no one had bothered to ask, was who Arnold Schwarzenegger had become in the quiet years after he left office. While the world moved on, chasing headlines and sound bites, Arnold went back to what he always valued more than fame, discipline. But this time not of the body, of the mind. After leaving Sacramento, he kept a promise he once made to himself back when he first stepped into American politics. That one day, when the cameras faded, he would finally study the law not as a politician, but as a student. No press release, no honorary degrees. Just a private man in his late 60s, walking into a law library at 6 a.m. before anyone else arrived, taking notes by hand, highlighting margins, reading until the sky changed color. While the media speculated about his next film or speaking engagement, Arnold was learning how the Constitution was built, line by line, case by case. He didn't enroll in any flashy Ivy League program. That wasn't his way. He preferred silence, study, depth. So he consulted retired judges, sat in on closed seminars, and built a private collection of legal journals and constitutional casebooks that spanned 2 walls of his home office. No one reported on it. That's exactly how he wanted it. Only a few of his closest aides noticed a shift. In meetings, he began quoting precedent instead of polling data. During international forums, he referenced Landmark Communications v. Virginia or New York Times v. Sullivan as easily as he once quoted box office numbers. What seemed like casual references were, in fact, part of a deep shift. Arnold wasn't just defending ideas anymore. He was preparing to defend them legally. So when the Supreme Court's ruling rolled in, one that stripped away key environmental protections on the grounds of federal overreach, something snapped, not in anger, but in certainty. He recognized the language, the framing, the legal gymnastics used to turn a safeguard into a barrier. And for the first time in years, he didn't just feel disappointed. He felt responsible. 3 days later, at the United Nations Climate Assembly, he gave the speech that triggered it all. Surrounded by global leaders, with cameras streaming live across 6 continents, he stepped up and, without notes, delivered a 5-minute address that didn't name names but shook institutions. We cannot pretend, he said, that decisions made behind closed doors by unelected judges don't have consequences for every child breathing the air outside today. The chamber fell silent. Delegates clapped. American networks flinched. Within hours, committee members in Washington began drafting a summons. What they didn't expect was how quickly he accepted it. Arnold didn't ask for lawyers. He didn't call his publicist. He didn't even notify his environmental foundation. He went quiet. For 72 hours, no one heard from him. His assistant said he canceled every call, every interview. Even his longtime housekeeper mentioned that his study light stayed on through the night. The only sound in the room was the soft click of page turns and the scrape of pen on paper. When his staff finally saw him again, he looked like a man who hadn't slept, but whose mind was on fire. He held up a stack of papers, bound with clips and covered in ink. "They want to test me?" he said, almost amused. "Good. Let's test them back, with their own laws." In that moment, it became clear this wasn't going to be a media stunt. He wasn't walking into that chamber to grandstand or provoke a reaction. He was walking in to argue, like a litigator, like a professor, like a man who had studied not for a grade, but for a reckoning. He had no interest in playing the victim. He wasn't going to cry censorship. He wasn't going to beg for civility. He believed in hard truth, spoken clearly, backed by law. And when he opened that briefcase before the committee, what lay inside wasn't just documents. It was preparation, intent, constitutional firepower. Those who saw him walk toward the Capitol that morning didn't recognize the transformation. There was no movie soundtrack playing, no motorcycle, no sunglasses, just a former governor with gray hair, a stiff gait, and a steel resolve. On the steps, reporters shouted questions. He didn't answer. He just raised one hand to signal calm and kept walking. Inside the chamber, some lawmakers whispered about the optics. "He's just here for attention," one aide muttered. "He'll fold." But they didn't know what he carried in that briefcase, or what he had buried in memory. Because in those 72 hours, Arnold had read every major Supreme Court decision related to freedom of speech, contempt, judicial criticism, and the separation of powers. He didn't just memorize the names. He understood their logic. He could explain their contradictions. He was prepared to cite the very sentences that judges had once written to protect voices just like his. And this was the part no one saw coming. For decades, Arnold had been underestimated. First because of his accent, then because of his muscles, later because of his movies. But every stage of his life, he had turned doubt into fuel. Now, for the first time, he wasn't here to lift anything. He was here to dismantle something far heavier, the idea that a citizen couldn't challenge power with clarity and win. The real weight he carried that day was in his hands. It was in the hundreds of hours no one had seen. The reading, the learning, the patience. And when he sat before the committee, opened his folder and looked up, not as a celebrity, but as a citizen armed with knowledge, they realized they hadn't summoned an actor. They'd summoned a man who had come ready to educate the room. And education, as they were about to learn, can be more disruptive than dissent. The calls started flooding in within minutes of the summons being made public. Senior advisors, former cabinet members, high-profile donors, even a few old friends from Hollywood, all with the same message, though wrapped in different words. Don't do this. Don't show up. Don't challenge them. They're not interested in truth. They're interested in making an example of you. By mid-afternoon, his inbox had over 140 unread messages, and his assistant had to mute every notification just to keep him focused. But Arnold wasn't pacing. He wasn't shouting. He wasn't even speaking. He sat in his study, eyes fixed on the open page of the dusty legal journal, pen in hand, annotating slowly. Meanwhile, across Washington and beyond, the machinery of politics was already spinning. Several think tanks issued bland statements distancing themselves from his UN remarks. A former senator called his speech ill-advised. One conservative radio host mocked him on air, saying, "Arnold's forgotten he's not in an action movie. This is real power, real consequences." That clip went viral in under an hour. It didn't matter. He wasn't watching. Inside the White House, the tension was worse. Arnold's foundation, the Future Earth Initiative, had several active partnerships with federal agencies. Senior staff were quietly panicking. Would the administration be forced to sever ties? Would his statement trigger a funding freeze? One aide suggested issuing a clarification on his behalf, saying his speech had been taken out of context. Another proposed drafting an apology and getting ahead of the narrative. They even prepared a talking point memo to circulate in case things spiraled. Arnold ignored all of it. He didn't attend the emergency Zoom calls. He didn't approve the press statements. He turned down every legal representative offered to him, despite repeated warnings from friends in government. "You need counsel," they said. "They'll eat you alive without it." He nodded politely, then went back to reading. A different kind of silence began to settle around him, not the silence of avoidance, but the silence of total internal clarity. On the second night, just after midnight, one of his oldest political allies, someone who'd once stood with him on the campaign trail, showed up unannounced at his door. The assistant tried to turn him away, but Arnold waved him in. They sat across from each other in the kitchen, just 2 cups of coffee between them. "You know what they're going to do, right?" the man said. "They'll paint you as arrogant, out of touch, the washed-up action star trying to play constitutional scholar." Arnold didn't answer right away. He took a sip, looked past the man toward the window, then said, "Let them." "You're not listening," his friend pressed. "You could lose everything. They'll frame it like you're attacking the judiciary, that you think you're smarter than the court." "I don't think I'm smarter," Arnold said. "I think I'm prepared." There was no bravado in his voice, no defiance, just a simple, immovable truth. "Then why do it alone?" his friend asked. "Why not send someone else to speak for you?" Arnold looked him in the eye. "Because I said the words. I take responsibility for them." That ended the conversation. Later that night, he opened a locked drawer in his study and pulled out a thin, worn notebook. Inside were notes from a meeting he'd had 15 years earlier with a retired justice who once told him, "The most dangerous person in the courtroom isn't the one who yells. It's the one who cites correctly." That line had stayed with him. Now it was a mission. By morning, the calls had slowed. Not because the crisis had passed, but because the people who tried to change his mind realized something rare. He couldn't be swayed. There was no spin, no plea bargain, no strategic retreat. He had already chosen his path. In the war rooms of D.C., this refusal to fold triggered a new wave of calculation. Some feared he would embarrass himself. Others feared something worse, that he wouldn't, that he would show up and dismantle the committee's case in full view of millions, that he would cite law more clearly than the lawyers, that his decades of discipline, which once built muscle, had now built something far more dangerous, command of the Constitution. And so the opposition began to prepare as well. They leaked rumors to the press about ego, about irrelevance. They framed his comments as a desperate grasp for attention. Some outlets aired segments questioning his legal understanding, reminding viewers that Arnold had never passed the bar. Others went deeper, suggesting he was setting a dangerous precedent by encouraging public distrust in the judiciary. The drumbeat grew louder, but it all missed the point. Arnold wasn't trying to win a culture war. He wasn't trying to score political points. He wasn't even trying to change the ruling, at least not in that room. What he wanted was far more specific. He wanted to prove that dissent, when rooted in law and principle, wasn't contempt. It was obligation. And so, while everyone else was calculating headlines, he was memorizing page numbers. While commentators rehearsed sound bites, he was rehearsing arguments. While the world guessed what he might do, he was locking in what he would do. By the time the hearing day arrived, his assistant found him already dressed, seated, hands folded over the briefcase that held his handwritten remarks and annotated precedents. He looked up with a slight nod and said, "Let's go." No theatrics, no quotes, no warm-up, because he hadn't come to perform. He had come to present. The room was already full when Arnold entered. Rows of polished wood, the dull hum of whispered speculation, camera lenses adjusting like eyes trying to focus on something they didn't fully understand. Committee members sat straight behind the long desk, flanked by aides who were already flipping through their briefing folders. No one stood to greet him. No introductions. Just a sharp tap of a gavel as the chairman cleared his throat and signaled the beginning. "Mr. Schwarzenegger," he began, voice level but stiff, "you are here today not because of who you were, but because of what you said. Your remarks during the United Nations Climate Assembly have raised serious questions about the limits of executive criticism directed at the judiciary. This committee is tasked with determining whether those remarks constituted contempt." Arnold said nothing yet. He waited, measured. Another member leaned forward, a congresswoman with a tone that suggested this was a matter already settled in her mind. "Let's be clear, Mr. Schwarzenegger. You used the phrase judicial sabotage. That's not constructive critique. That's an accusation. and it challenges the very legitimacy of our courts. Arnold lifted the microphone slowly, adjusted it without sound, and spoke his first words of the day. Then let's talk about legitimacy. The pause that followed wasn't planned. It was instinct. He had learned long ago that stillness can be louder than speech. I've been accused of undermining the judiciary, he continued, voice low and steady. But in this country, questioning decisions is not an attack. It's participation. The chairman shifted in his seat. This isn't a town hall, Mr. Schwarzenegger. You're not here to deliver speeches. This is a legal inquiry. Good, Arnold said, pulling open his folder, because I've come with the law. He held up a single sheet, thick with notes and highlights. Bridges versus California, 1941. The Supreme Court ruled that even harsh criticism of the judiciary is protected under the First Amendment unless it presents a clear and present danger to the administration of justice. My comments, while strong, were about the implications of a ruling, not the personal integrity of the justices who made it. A few murmurs. One aide scribbled something. Another leaned in to whisper. But Arnold didn't stop. In New York Times versus Sullivan, this court emphasized that debate on public issues should be uninhibited, robust, and wide open. That includes statements which are vehement, caustic, and sometimes unpleasantly sharp. They were not talking about polite disagreement. They were talking about the responsibility to challenge power. A younger representative raised a hand, clearly irritated. Are you suggesting that your platform entitles you to disregard the weight of judicial decisions? No, Arnold said plainly. I'm saying my platform makes silence a greater sin. He flipped to another tab. In Landmark Communications versus Virginia, the court ruled that even speech which might harm the reputation of a judge is protected if it addresses a matter of public concern. The environment, our future, is such a matter. The chairman interrupted. Mr. Schwarzenegger, you're not a lawyer. You've never been admitted to the bar. And yet you stand here quoting case law. Don't you think that's presumptuous? Arnold looked up. I've never been a soldier either, but I've trained with some of the best. You don't need a badge to respect the battlefield. You just need to know what's at stake. There was a quiet shift in the room, a recalibration. He wasn't there to posture. He was defending each sentence like it was a legal exhibit, not with force, but with focus. He turned to the next page. I understand that, as a public figure, my words carry weight. That's exactly why I chose them carefully, and that's why I stand by them. Another voice broke in, a senior congressman with a smirk. What are we supposed to believe here, Mr. Schwarzenegger? That you, bodybuilder, actor, politician, are now a constitutional scholar? Arnold didn't blink. No, but I'm a citizen who can read. That answer landed heavier than expected. He gestured toward the panel. The law isn't reserved for robes. It belongs to all of us. And when rulings affect the air our children breathe, the water they drink, the planet they inherit, I will not apologize for calling attention to it, even if it makes this room uncomfortable. One of the aides to the left stopped typing. The room was still again. Arnold closed the folder gently and folded his hands. I'm not here to dismantle the authority of this institution. I'm here to remind you that authority without accountability is not justice. It's control. The chairman leaned forward, clearly agitated. You've made your point, Mr. Schwarzenegger. Arnold nodded once. And I'm done. I've said everything I came to say. The gavel didn't fall immediately. There was hesitation, a recognition, perhaps, that something unscripted had just happened. The hearing was supposed to be a reprimand, a containment. But what they got instead was a lesson, measured, deliberate, and unshakably rooted in precedent. The chairman finally spoke. This committee will adjourn to deliberate. Arnold rose, calmly gathered his materials, and stepped away from the microphone. He didn't look back, and as the cameras followed him out, the silence left behind said more than any ruling that day could. The clip went viral before Arnold even reached the car. 27 seconds of unbroken footage showing him calmly citing landmark constitutional cases, ending with a line, "The law isn't reserved for robes. It belongs to all of us." By the time he stepped into the back seat, the internet had already given him a new name, the Constitutional Terminator. On Capitol Hill, Aides scrambled to adjust statements. What was meant to be a quiet disciplinary hearing had erupted into something else entirely, a national moment. Inside law schools, the shift was immediate. Professors paused mid-lecture to stream the hearing. Students whispered about his citations, not just for their accuracy, but for the way he delivered them without notes. Harvard Law issued a tweet within hours. Today's committee testimony by Arnold Schwarzenegger will be analyzed in next week's seminar on First Amendment boundaries. Prepare accordingly. Stanford posted a similar announcement, and Yale scheduled a panel by evening. In the media, the tone began to change. What had been skepticism turned into reluctant admiration. Pundits who had dismissed him earlier now marveled at how he'd maintained composure, rebutted legal arguments with case law, and avoided even a hint of theatrics. More surprising, some legal experts began to admit something they hadn't expected. He wasn't just quoting precedent. He was applying it, properly. CNN's chief legal correspondent leaned into the camera and said, "I've seen lawyers struggle to argue these precedents under pressure." Arnold not only recited them, he linked them together like a trained litigator. On the other side of the aisle, conservative commentator Daniel Reeves stated, "I don't agree with his views on the environment, but you have to respect the way he stood there and faced that room with nothing but facts. That's not ego. That's preparation." But perhaps the most striking reactions came from within the legal system itself. A retired appellate judge posted a thread breaking down each of Arnold's citations, ending with a note. "I've been on the bench for 27 years. I've seen law clerks misinterpret those cases. He didn't." Her post received over 1 million likes in 12 hours. Back at the Capitol, the committee sat in closed-door deliberations longer than anyone expected. They had not anticipated this. The plan had been straightforward. Put a public figure on the defensive, show the court could not be challenged without consequence, reassert control. But the moment Arnold flipped the conversation into constitutional analysis, the dynamic shifted. Instead of defending himself, he had put them on trial. Their assumptions, their readiness, their own understanding of the very principles they were sworn to uphold. Some members wanted to issue a warning. Others worried that doing so now would appear petty. One staffer reportedly said, "We can't punish him for being right." Another whispered, "What if we're the ones who look unprepared?" Meanwhile, Arnold sat alone in a small office down the hall, sipping water and reading silently. His assistant had offered to bring him a phone, but he declined. He wasn't interested in how it was playing online. That part didn't matter. What mattered was whether the message had landed. In the room, in the law, and in the minds of anyone watching who still believed that silence was safer than truth. Outside, reporters gathered near the Capitol steps. A few shouted questions whenever a door creaked open. Will there be a formal censure? Is Arnold facing consequences? Was this a political stunt? No one answered. Inside, however, the questions were sharper. What precedent will we be setting if we reprimand someone for quoting the Constitution? Do we really want this to be the headline tomorrow? Is it contempt or just inconvenient honesty? By early evening, whispers began circulating that no formal punishment would be pursued. The story had outgrown the process. The committee, once firm in its resolve, was now navigating optics, and Arnold, calm, unwavering, unflinching, had become more than a witness. He had become the standard. That night, a clip resurfaced from a 1991 interview, where young Arnold was asked about his biggest fear. He answered, being underestimated, because that's when people stop watching. Now, decades later, the very underestimation that followed him from Austria to Hollywood, from bodybuilding to politics, had given him the element of surprise. Again, in living rooms across the country, people watched the footage with their children, not because it was entertaining, because it meant something. It was a reminder that dignity doesn't require volume, that clarity can be a weapon, and that age or background or career should never disqualify someone from speaking with conviction. One teacher in Michigan paused her civics class to show her students the full hearing. Afterward, a quiet boy in the back raised his hand and said, "So you don't have to be a judge to know the rules. You just have to care enough to learn them." She wrote that sentence on the board and left it there for the rest of the week. Arnold returned home late that night. The lights were low. His study was still open. He placed the folder on the desk, undid the last button of his jacket, and sat in silence. No fanfare, no celebration, just the quiet presence of a man who had carried the Constitution, not as armor, but as compass. He knew the final decision would come in 48 hours. But deep down, he also knew something had already shifted, something no ruling could undo, because in the battle between power and principle, he hadn't just offended his words. He had restored their meaning. The next morning, headlines didn't just report what had happened. They tried to explain it. Schwarzenegger shocks Congress with constitutional defense. From action hero to legal hero. The most unexpected law lesson on Capitol Hill. But what caught most people off guard wasn't the media spin. It was the tone. There was no sarcasm, no dismissal, just awe. Something had changed. Not only had Arnold refused to apologize, he had left the nation's most powerful lawmakers speechless. And now, the ripples were reaching every corner of American civic life. Law schools were the first to respond. Georgetown Law announced an emergency seminar titled Executive Speech and Judicial Boundaries, Lessons from Schwarzenegger. Within hours, seats were full. At Columbia, a constitutional law professor opened his lecture by playing the full clip of Arnold's testimony. Not to entertain, but to analyze. Listen not to his fame, he told the room, but to his logic. One student asked if this would be on the final exam. It should be, the professor replied, because this is what constitutional courage looks like. Universities weren't the only ones watching. Civic educators in high schools began writing new lesson plans overnight. A social studies teacher in Texas posted a video explaining Bridges versus California, using Arnold's testimony as a real-world example. It got 3 million views in 2 days. In Chicago, a civics club created T-shirts with the words, "The law isn't reserved for rogues." They sold out before the weekend. The American Bar Association issued a formal statement acknowledging a rare moment when a non-lawyer had offered what it called an exemplary public engagement with First Amendment doctrine. Legal blogs debated not whether Arnold was right, but how long it had been since anyone had articulated those principles so clearly in front of elected officials. Some even argued that his testimony should be required viewing for incoming congressional staffers. Meanwhile, in private chambers, the committee remained uncharacteristically quiet. No leaks, no whispers, only a sense that something irreversible had occurred. They had summoned a man to answer for his words, and instead found themselves sitting through a masterclass in constitutional restraint. For some, it was humbling. For others, a warning. And for the youngest aides in the room, it was inspiring. One intern reportedly told her supervisor, "I didn't come to D.C. to write sound bites. I came here for exactly that." Back at Arnold's home, the phone didn't stop ringing. Producers wanted interviews. Networks offered primetime specials. A documentary filmmaker emailed a full proposal titled The People's Briefcase. Arnold declined them all. He wasn't looking for attention. What he had done wasn't performance. It was principle. And principles don't need a spotlight. They just need to be heard once, clearly and at the right time. He did, however, make time for a private call from a law professor in Vienna. The man thanked him not for what he said, but for how he said it. "In a world of noise," the professor said, "you whispered facts and the world leaned in." Arnold listened, then simply replied, "It was never about being loud. It was about being grounded." Social media, predictably, took it further. Artists turned his quotes into murals. Animators created short explainer videos featuring a cartoon Arnold pulling law books from his briefcase. A viral remix set his speech to orchestral music, timed perfectly with each citation. But beneath the spectacle was something rare, respect, not manufactured, not forced, earned. Even those who disagreed with him on policy found themselves admitting the undeniable. One senator tweeted, "I still oppose his interpretation of the ruling, but I teach law, and I recognize sharp argument when I see it. He made us listen. That matters." A prominent judge, writing under a pseudonym, submitted an op-ed titled, "The Day We Were Cross-Examined by a Citizen." It ended with the line, He didn't mock us. He challenged us to live up to the robes we wear. And that's what lingered. This wasn't about Arnold Schwarzenegger, the celebrity. It wasn't even about Arnold, the politician. It was about a man who took the most powerful room in the country and reminded it that its real power came not from gavel strikes, but from grounded thinking and public accountability. That weekend, churches, universities, barbershops, and cafes all buzzed with the same question. When did we start believing that only lawyers can understand the law? Arnold's testimony had cracked something open, a forgotten truth that civic participation isn't reserved for elites. It belongs to the prepared, the curious, the bold, and the responsible. In one classroom, a 13-year-old girl raised her hand and asked, if he could do that just by reading and learning, why can't I? The teacher smiled, not because of the question, but because of what it meant. The point had landed. The ripple had started. By Monday, a petition was circulating to add Arnold's testimony to the national civics curriculum. It gathered over 100,000 signatures in 48 hours. Whether it passed or not didn't matter. The idea had already taken root. Because while some tried to reduce what happened to a media moment, others knew better. What Arnold had done wasn't viral. It was vital. And in the process, he hadn't just won an argument. He had reminded the nation of something essential, that in a democracy, clarity is power. That reason still holds weight. And that when spoken with humility, truth doesn't just echo, it multiplies. 48 hours after the hearing, the committee released its official statement. It was brief, 3 paragraphs, no dramatic language, no mention of discipline or contempt, just a quiet acknowledgement that the remarks made by Mr. Schwarzenegger fell within the scope of constitutionally protected speech, and that no further action would be taken. But beneath the legal formality, the meaning was unmistakable. He hadn't just avoided punishment. He had reset the terms of the entire conversation. For the first time in years, Congress had backed away from a confrontation. Not out of fear, but out of respect. Arnold read the statement alone, sitting by the window in his study. He didn't smile. He didn't react. He just folded the letter in half, placed it in a folder, and tucked it away behind a row of books, as if storing for history, not headlines. Outside, the light shifted on the street. A few kids walked by on their way home from school, laughing, kicking a ball. He watched them quietly, thinking not about the chamber or the cameras, but about what those kids would inherit. That was always the point. Not to win an argument, to protect what mattered. Later that day, he received an unexpected invitation. Notre Dame Law School, the same institution where Justice Barrett had once taught, asked if he would consider speaking at their spring lecture on constitutional dialogue in divided times. The irony was not lost on him. Neither was the opportunity. He agreed on one condition, that it would be open to students, not just faculty, and that no topic would be off limits. The university agreed. When the day arrived, the lecture hall filled faster than expected. Students lined the aisles. Faculty stood at the back. Reporters weren't allowed inside, but their cameras waited outside the glass doors, hoping for even a glimpse. Arnold entered quietly, carrying nothing but a small notepad. No speech, no slideshow, just presence. He stood at the front of the room, looked across the audience, and said, "The last time I was this close to a law school podium, people thought I was out of my depth. I was, until I studied, until I cared. That's the thing about the Constitution. It doesn't demand perfection. It just demands participation." The room didn't move. Every eye was locked on him. "I didn't come here to tell you what to think," he continued. "I came to show you what happens when you refuse to stay silent in the face of institutional certainty. Not because you want to be loud, but because you want to be accurate." He paused and added, "Civic courage isn't about yelling at power. It's about knowing the rules well enough to challenge power by its own standards. That's not rebellion. That's respect." A student raised her hand and asked what changed in him. What made him go from governor to constitutional advocate? He thought for a moment, then said, "When I was a young bodybuilder, I thought strength was about force. Then I became an actor, and I thought it was about presence. Later in politics, I believed it came from influence. But now I know the truth. Strength is clarity. knowing what you believe and why, and being able to explain it to someone who thinks you're wrong without raising your voice. The room stayed silent, not because there was nothing to say, but because no one wanted to break the moment. Afterward, as he left the hall, a professor followed him outside. She was one of the nation's foremost experts on constitutional law. She walked beside him for a few moments before quietly saying, "We've had Supreme Court clerks who couldn't have argued those cases the way you did. Not with that kind of precision, that kind of calm." Arnold nodded once. "I didn't want to win. I wanted to be correct." She stopped walking. "You were?" "Back home." He returned to his quiet routine. Morning walks, reading, answering letters from students. He received hundreds, some from law students, others from teenagers who'd never even read the First Amendment before watching the hearing. One letter, written in careful penmanship, came from a high school freshman in Ohio. It read, "I used to think you had to be someone important to say something important, but now I know it's the other way around." That one he didn't file away. He placed it in a frame on his desk. Weeks passed, then months. The story faded from the headlines, as they always do. But something lingered. The phrase he had said, "The law isn't reserved for rogues," began to appear in unexpected places. On posters in classrooms, in op-eds, even on the side of a civic education bus traveling across rural counties to teach kids how government worked. Quiet echoes of a moment that refused to be reduced to a soundbite. Then one afternoon, almost 6 months after the hearing, Arnold returned to Washington for a private reception. No press, no podium, just a small gathering at the Library of Congress to unveil a new exhibit on landmark civic moments. Among the archival documents, court opinions, and protest photographs sat a glass case. Inside, carefully preserved, was the folder he had carried into the committee hearing. A small plaque beneath it read, "Citizen Testimony, Arnold Schwarzenegger, 2025. Quoting precedent, defending principle." He stood in front of it for a while, alone, not with pride, but with peace. Because in the end, the greatest thing he'd ever lifted wasn't a barbell or a box office record. It was the burden of speaking truth with discipline in a room built to silence it. And when he left, he didn't take a photo. He just walked outside into the light, quietly, as always, believing more than ever that in a democracy, the loudest voice isn't the most powerful one. The most powerful one is the one that speaks last, and speaks clearly.